First case on our calendar is matter of Teamsters Local 445 versus Town of Monroe. Counsel.
May it please the court. Good afternoon, distinguished judges. My name is Brian Nugent with the law firm of Ferrick, Nugent, McCartney, representing the respondent appellant, Town of Monroe, in this proceeding. Here with me to my left is my colleague, attorney Matthew Lazat, who was on the brief, and to his left, partner Alex Shaw from our firm. First, congratulations, Chief Judge, on your appointment, and Associate Judge Halligan on your appointment. I would like to request to reserve 1 minute for rebuttal.
Of course.
Thank you. Your Honors, why is this case important? If the second department decision below is allowed to stand as the law of this state, it will affect a significant change to the law by allowing municipal and state officials to appoint an exempt class employee who need not demonstrate any qualifications and need not pass an examination to then be converted into a permanent class employee which is in violation of this state's public policy.
Is there no manner for removal?
I'm sorry, Your
Is
Honor?
there no manner for removal? No path for removal? When you say a permanent employee?
Their only path would be, under the respondent's argument, through a demonstration of incompetency or misconduct under Section 75 of the Civil Service Law. And we believe, because of the at-will nature of the exempt class, that they cannot be brought into the coverage of Section 75 of the Civil Service Law.
And why should exempt classes be treated differently?
Well, the main reason is, in the first place, Section 75, the legislative body in New York State excluded the exempt class from Section 75. So all of the cases in this state that concern modifying or supplementing the provisions of Section 75 and 76 concern those employees in the classes that are protected, the competitive class, the non-competitive class. But the decisional law of this state has never conferred the Section 75 benefits onto the exempt class, and that is for good reason. The main one being that you can't accomplish that without contravening Civil Service Law Section 20 that delegates the authority exclusively
Why isn't all of that arbitrable?
I'm sorry?
Why doesn't that just go to the arbitrator? What public policy would it violate to have an arbitrator
Well,
hear your argument on this? Put aside any other question about ambiguity in the CBA itself.
Yes, so the main public policy, and I think it was set forth well in a third department case of Martin v. Hennessy, where this exact situation happened, except the difference is there was no collective bargaining agreement. There was a designation of exempt class employee placed and granted by Resolution 75 protection. And the court there set forth the public policies and the contravention of statute, which was, it was a reclassification of the exempt class employee to confer the protections of Section 75 and essentially convert that exempt class employee to one that was protected.
But that was a slightly different factual scenario, right? That was, this is a situation where the hiring authority and the union got together and agreed to do this. It was more unilateral in that case, wasn't it?
Well, in the Thruway Authority case in Martin, it was a resolution of the board there. Whether there was agreement, I'm not aware in the background. But you're correct that this situation arose from a collective bargaining negotiation. But the public policy of the state has been expressed, for example, in this court's decision in Chautauqua, that favoring the policy for arbitration is not without limits.
Is it absolutely unprecedented that exempt class employees are ever afforded Article 75 protections? Are you saying that that's just unheard of if the structure is followed correctly?
The exempt class, as such, has never been protected by Section 75. The only distinction is that there are, which have long been the case in New York State, preference for veterans and volunteer firefighters, where that statute just says anybody in the classified service that is a veteran or a volunteer firefighter could achieve protection. But to allow this case to stand actually undermines that legislative intent and that statute that granted that specific protection onto those classes, and now says that any exempt employee could be a political appointment that is brought in without qualification and examination, gets converted to a protected class, and then we have the issue of now binding successor boards that no longer have the ability to remove that at-will employee that they would have had and they should have had, and it's taken away.
What about the labor class? I'm sorry, Judge Halligan.
Well, thank you. Are you asking us to look only at the removal protection specifically? For example, could there be a different result with respect to a notice provision?
No, in our view, we are looking to have the arbitration permanently prevented because there's no relief here that could be granted that would not violate public policy, that would not violate those provisions 20 and 41C of the Civil Service Law. And while 76 in the Civil Service Law, Subdivision 4, does allow for modification or supplementation of collective bargaining agreements, it does not allow the modification of Civil Service Law 20 regarding reclassification and appointment, and it doesn't allow modification of Section 41, which declares this position statutorily exempt.
Just if I could follow up on Judge Halligan's question. I think the question is, what if you had just bargained for notice prior to termination? Not for any procedural rights, not for a just cause termination, but just for a notice.
Just 2 weeks' notice, something like that.
Well,
termination.
I think in the first place, obviously notice would be given to tell somebody that they're terminated, whether they could bargain for a 2-week notice, to make them aware. I can't say that that violates the public policy as long as it doesn't interfere with the termination. It slightly interferes with the at-will nature of the termination by putting a time frame on it. But in this case, we're dealing with having to provide a hearing and demonstrate incompetency and misconduct.
Can the exempt employee be a member of the bargaining unit?
Yeah, the town is not disputing, and I think in this state there are plenty of examples of exempt class employees being within a bargaining unit, the only exception being those that might be defined as managerial or confidential, which is not the case in the town of Monroe situation. So we aren't taking the position.
If the town had wanted to, the town determined really this should be a non-exempt classification, what could they do about that? Anything?
I'm sorry, Your Honor.
Sure, if they decided, this isn't really an exempt position, we want to reclassify the position itself as a non-exempt one, how do they go about doing that, if at all?
So if there was going to be a reclassification, it would follow the provisions of Civil Service Law Section 20, which would be the local municipal civil service commission. Typically, they would send a job description and say, we wish to reclassify this, for example, to a competitive clerk position or a, standard clerk position.
But in fact, isn't there an additional layer here in Section 41? As I read Section 41(2), whenever one of these positions becomes open, there has to be an assessment done in terms of whether or not it should continue as exempt. Is that right?
I believe that's what the statute says. In this case, there wasn't an opening at the time.
No, I'm talking about this case with the opening, but it seems to me that that is required for any position, when I'm talking about here. But in general, 41 provides for a process to re-examine each of these positions to determine if it should continue exempt under the criteria for exempting a position. Is that right?
Yeah, I believe the statute provides for that re-examination.
In
And
2018, here, counsel, in 2018, the tenure protections were extended to labor classified jobs before it was altered in 75. So if they could do it, the ledge could do it then for them, why not for these exempt employees?
Your Honor, I think the legislature could, if they chose to do so, confer protections by legislative act. But I think that's something different than a collective bargaining agreement performing the same task merely by signing an agreement and now bringing the exempt class within the provisions of the statute. Also, because even if this court were to agree that you could bring in exempt class into Civil Service 75, you still run into the roadblock of reclassification and Section 41, which do not allow that statutory contravention to protect the exempt class. I see my time is up. If there are any other questions?
Thank you,
All
Counsel.
right, thank you.
May it please the court, Louis Nicolaitis for the firm Lewis Clifton Nicolaitis. I represent the union in this matter. And I guess it's important to remember that this is a voluntary act of the employer. The employer wasn't forced to do this. They did it not only once, but they did it in more than one collective bargaining agreement. In collective bargaining, there's always pluses and minuses when you negotiate.
What exactly are you saying they did that tied their hands?
What was that, Judge?
What is it that they exactly did that
They
tied their hands?
negotiated this position specifically and put it into the collective bargaining agreement and gave this position certain rights. And they didn't do that for every exempt employee. There was another exempt employee of the bookkeeper, and they specifically excluded that position from the due process just cause provisions. They could have done it here, and they didn't. And when
Do
they
you have
do-
any other authority, can you cite any case or any other authority that allows exempt employees to be affected by the CBA?
There are 3 cases we cited in the brief, Ruiz, Day, and Lake Grove, all of which said that you could extend rights under a collective bargaining agreement to classifications of employees that are not particularly covered by Section 75 and 76. They don't specifically in those decisions say exempt employees, but exempt employees by definition are outside of those protections. All 3 of those cases say that. There is no case that we are aware of where it does the reverse, which takes the petitioner's position that it cannot be done.
Counsel,
There's no
go-
case that I'm aware of in any court in New York that says once you've signed a collective bargaining agreement, you've given certain rights to people, they can just willy-nilly be taken away.
Going back to your first statement about how the employer chose to do this along with the union, what gives the employer the right to act arguably extra statutorily?
They don't have a right to explicitly contradict a statute, but there is no statute in this case that is explicitly contradicted. This issue of whether exempt employees can be covered by a collective bargaining agreement is not specifically
But that's
addressed
not
in
really
cases.
our standard. Our standard is legislative intent to remove the issue from mandatory bargaining, right? I mean, it's not that it has to say you can't bargain this. I think our approach, this court, is you look at the statutes and say, is there room for bargaining here, given what the legislature has set out? And again, to go back to these provisions, the exempt position is classified this way because of certain criteria, right? The nature of the position. And under the section governing that, in Section 2, there is this provision that provides for this review periodically of whether these should remain exempt. It seems to me that provision now is going to mean nothing because there's not going to be this. You've taken it out and there's need to be any, you've made it essentially a permanent position.
Judge, I think the point you said that's most pertinent is voluntary. This was a voluntary decision of the employer to...
Overturned voluntary decisions before, and particularly in this case where you're binding a future employee in an exempt position that's designed to be something for that individual based on, again, those criteria that lead it to be exempt, and you're binding that future employer and not be able to fill that with the person contemplated under an exempt type position.
But you are not. Each time a collective bargaining round comes up, the employer has the right to say, if it's a voluntary subject of bargaining, we're not going to bargain over it. In the context of the existing collective bargaining agreement...
I come in, I get one of these positions, now you come and you tell me I can't replace this exempt position that I want to. I have to wait till the next round of collective bargaining to see if I can get that provision.
What you can do is you can go to the legislative agency that has the expertise in the area and file a petition for unit clarification. If they want to exclude that person from the contract, exclude them from any rights within the contract, they can do that anytime they want to. There's no restrictions on doing that.
Counsel,
you-
go ahead.
Do you have a view, counsel, about whether the town's position would affect collective bargaining agreements beyond the one at issue before us today?
No, it will not. When there is a renewal of agreement, like I said, they can take the choice, they can take the position that it's a voluntary subject to bargaining and not bargain over it and say, we're not going to include that position in the collective bargaining agreement.
So
It's
suppose-
there
But are you
for the
aware-
This whole situation happened during the term of an agreement. During the term of agreement, they can't just violate the agreement. They have a
So
statutory remedy if they want to exclude that person
suppose the
from the
employee
agreement.
had been management confidential instead of exempt. Could you still say, this is voluntary, the employer can include the employee?
In fact, yes, they have done that, and the remedy to exclude that person is to file that petition with PERB. If an employer thinks it made a mistake by including a position that should not have been in the agreement,
Well, what if,
they
I'm
can't just
sorry,
take it out.
what if the
They have to
employer
go through the
doesn't, what if the
process.
employer doesn't think that they made the mistake because they agreed to it? I mean, isn't there a public policy that at least as to management confidential personnel, that you shouldn't be
Yes.
able by contract to agree to exclude them?
There's a public policy and there's a procedure for enforcing that public policy. They go together, they're hand in hand. You can't just unilaterally make the decision to include them and then pull them out without going through that procedure. And that procedure is well laid out. Employers know how to deal with it. You file a petition with PERB, they've got the expertise.
Even
and
if
they
the
can exclude it.
inclusion is contrary to the statute?
It has, if it's contrary to the specific language of the statute, you may have a point, but there's no specific language
If
of a
it's
statute
contrary to
here.
the scheme, the actual classification scheme. I understand your position about an express statement, but if that was indeed the standard, if that's what we were going to decide, we all wouldn't be here. This is not express. But the question is whether or not it violates what is the scheme that the legislature has chosen.
Well, that's kind of a broad definition in terms of the scheme,
Mm-hmm.
especially when you're dealing with the matter of labor law, the Taylor Act, where there is a strong public policy to support employees in their rights to collective bargaining or to join or not to join a union. That's a strong public
But there are
policy. I don't know if that can
exclusions.
be violated by a
Counsel?
quote scheme.
But there are instances where not all are included within the collective bargaining unit.
Absolutely. Employers have, that's a voluntary subject to bargaining. If it's a voluntary subject and the employer says, no, I'm not going to do it, the union can't do anything about it.
So a predecessor here can bind a successor.
No, when the new contract comes up for negotiations, it's all square one again. The employer in that new negotiation can say, we are not going to agree to continue to have this title in the contract. They have a right to do that.
But my understanding of the scheme with respect to these exempts and confidential types of classifications is that when a new hiring authority comes in, when there's a regime change, that we have a new town board, a new mayor, that they might want to put their own person in that position. And what I hear you saying is you may be stuck with that person for 2 years or 2 years and 10 months, and your opportunity to put your own person in is lost until you renegotiate. Is that really what the scheme intended?
No, you can go to PERB and try to do it in the terms of a collective bargaining agreement to have them excluded. PERB has the authority to say that position was mischaracterized, it should not have been in the collective bargaining agreement. They have a right to do that, and they can do that. The employer has a right. In this case, the employer didn't exercise any of those rights.
But the time frame for the hiring authority, you might have a new hiring authority, I take it, even though the collective bargaining agreement is still running for some
Yes.
period of time.
But that's the nature of collective bargaining agreements. When there's a new administration that comes to power, they can't say, oh, we don't like the terms of the agreement. We think you're getting paid too much. We want to change that. It doesn't run due to the term of the elected office. It runs for a specific numerical term, and they're just stuck with it. That's
Yeah,
the
but isn't
nature
that
of collective
contrary to
bargaining.
public policy? You're stuck with someone in a position where you need trust, you need confidentiality, you need to put your own people there. Like, isn't your whole argument contrary to public policy if you say, sorry, you have to wait till next time around?
No, because I said they don't have to wait till next time. They have a statutory way of getting rid of that person. And they didn't have to negotiate in the first place. As you were talking about earlier, there's two issues here. One is the procedural rights to know what they're doing and the reason why they're doing that. That contract says all employees have to be given a written explanation of why they're being terminated. And then there's a second question about how do you determine whether they can be terminated or not. We say they have to show just cause. But those are the two aspects of it,
But why-
both
why-
of which they
why-
voluntarily negotiated.
Counsel, why should the PERB process be exclusive Why can't they just go directly, as they've done, to court and have the judges decide that issue? I
Because,
think we can interpret statutes
because
just
in
as
labor law,
well.
we've developed a statutory framework that does not allow employers to unilaterally make those kinds of changes. If there was no Taylor law, if there was no labor law, yeah, they could do that.
But in
If
city-
everyone here was employee at will, of course, they could do that, but that's the whole nature of collective bargaining.
City of Long Beach.
It takes unions, it takes
Counsel,
individuals out of that
counsel, in
situation.
City of Long Beach?
What's
were we-
that?
City of Long Beach
Oh,
provisional
that's a
employee?
completely different case. That's a case where you're talking about a provisional employee. And there's specific language.
Okay, so it's a provisional employee, but
Yeah.
they're covered by the
But-
CBA, right? That, in that case.
Well, they're probably not, because in the sense that they're probationary and they're never going to get past probation based on the length of terms of
Well, they
probation.
were tempted
Because
to
it's
cover
very
them in-
li-
okay,
you can
let me-
only serve
Let
very,
me
in a very
rephrase.
limited
They
period.
attempted to cover them in the CBA, in City of Long Beach, right?
Yeah, they did.
Did they follow this procedure you're talking about first?
In this procedure, what the court had said was there's specific language in civil service law that put a restriction on how long a provisional could stay in the job. There has to be a quick testing for it, and when there's a testing, then that
So if it's
provisional
clear
has no
enough-
right to stay in the position. That was
If it's
different
clear
here.
enough, then you don't have to follow this other procedure. But if it's not that clear, then you have to follow the other procedure.
Well, if there's a very specific legislative procedure, then it takes precedence unless it's unconstitutional, of course. It could be challenged on that grounds. But if there is a specific legislative procedure, you follow it. But if there's no specific legislative procedure and there's a strong public policy supporting the right of unions to form and members to join or not join the unions, you have to balance that strong public policy. And in this case, we say there is no language that they have pointed to in civil service law that says that an exempt employee cannot be given protections under the collective bargaining agreement. And
Thank you,
the
counsel.
three cases I cited for
Thank
you
you.
are all three cases that said exactly that.
Counsel, thank you. Your time's up.
Thank you.
So why isn't he right that PERB is the exclusive path?
As far as
It's
the...
an exclusive path to resolve the problem?
Yeah, so first of all, the, unit clarification, are you referring to that process or going to have the
Well,
person?
that was his response when I asked about is that the exclusive path? And he said yes, so I'm asking you, unless you can't possibly agree with that, why is that
No,
wrong?
and I think that the first thing, is obviously you can't, this concept of a voluntary act is meaningless, because that would just say that a collective bargaining union and a town can violate statute as long as they volunteered to do it. And so the only path when there's a violation of public policy and contravention of statute is to prevent arbitration, not to follow some other path, because there is no path other than that's the end of the story. They're exempt, they cannot be protected. And secondly, this point about the collective bargaining agreement that it could be changed down the road is also not accurate, because an outgoing town supervisor puts an exempt employee into a protected class, gets them a collective bargaining agreement, a new agreement, that may go 4 to 5 years. That supervisor's term might be 2 years. He has no ability to replace or have his choice put in, and he can't remove the person that the former supervisor put in. So that concept that we can renegotiate later is problematic.
And am I
also the
correct,
path-
you might also very well, sorry,
Sorry.
am I correct, you might also very well be taking some time to renegotiate the CBA, and the old CBA will stay in place during that period of time? So it might actually be quite a long time? Am I correct?
To
If That is
renegotiate.
possible, correct.
It would
Yes.
be a long time, yes.
It could possibly be quite a long time.
It could be up to, on average,
You
I
may
would say.
continue under the old CBA until you enter a new CBA.
Well, under the Taylor law, and that was the next point I was going to make, is that even if that collective bargaining agreement expires, the Taylor law requires those terms and conditions to continue until the successor is negotiated. And then you have to negotiate, and the union may not agree, to remove that title from the union. So this court's decision in Chautauqua, I think, makes this very clear, that if you can look at this collective bargaining agreement and you could look at these statutes that we've cited in the civil service law and conclude that any relief would violate public policy, then there cannot be arbitration on the exempt employee in a union like this.
Thank you.
Thank you, Your Honors.